Go right ahead. Thanks, Judge.
Hello, friends. Welcome to Reversing Final Judgments, a close reading of Automotive Finance v. Ming Liu, a Indiana Supreme Court decision that recently came down. Just a couple of matters of housekeeping. Several people have asked how these close readings came about. And before I was a lawyer, I was an English teacher. And in grad school, the class was often us sitting around a circle, reading a poem or a chapter with the line by line with the professor making comments. I remember doing that vividly with Tim O'Brien's The Things They Carried or Louise Erdrich's Love Medicine. Then as a bankruptcy lawyer, I would plan CLEs for the debtors bar, and I got to wondering whether a close reading would work for an appellate decision. Then coincidentally, I came across a tweet by Emily Bremer, who's a law prof at Notre Dame, and she said, really can't overstate how valuable it is to periodically reread unedited versions of foundational cases. So that's what we're trying to do here. So this is our third close reading. We've done two cases previously. First was Welton v. Midland Funding, an appellate court decision written by St. Joseph County's own Mike Barnes on summary judgments and the various deadlines associated with it. And the other was, second was Lewis v. Rex Metal by Judge Terry Crone, another St. Joseph County native on aging judgments. So thank you to Amy McGuire, the executive director of the St. Joseph County Bar Association, who did all the paperwork to make this happen. She's given you instructions on how to get your CLE credit. Next, we are joined today by Ian Flora and Ian Septoski. I have 4,800 contacts in my phone, but only two Ians, and both of them are going to co-teach this with me. So Ians, could you please take 30 seconds to introduce yourself, tell where you grew up, where you went to law school, if you have a family, where you practice, anything like that.
I'll go ahead. Yeah, my name is Ian Septoski. I'm an attorney here in South Bend. I've been practicing for 20 years. I graduated from Purdue and then Valparaiso Law School. My wife is also an attorney, and I have two young kids who keep us busy.
Very good. Thank you. Ian Flora?
Yep, I'm an attorney from South Bend. I've been practicing just 1 year less than Mr. Septowski. I went to IU Bloomington and IU Indy for law school, and my practice area is pretty much every aspect of creditors' rights, and that mostly has me in courtrooms all over northern Indiana. I think the first time we did one of these, I was in a attorney room in the Valparaiso courthouse. The second time I was in the same room in Kosciuszko, and today I'm in a gas station in Pierceton, going from court Valparaiso to Fort Wayne in the afternoon. So I travel doing a lot of, I see a lot of motions to set aside judgments, and excited that we're going to talk about one today.
Okay, very good. Nell Newton, the former dean at Notre Dame Law School, told me once that the key to success was surrounding yourself with people who are smarter than you. And that's clearly what I've done in this situation. Next, for the sake of time, I will just be reading the text, not the citations in full or the footnotes. Please press mute on your Zoom settings so your background noise doesn't interfere. Finally, Chief Justice Rush had indicated she might listen in, or maybe her clerks would. Are any of them present?
Okay, now what?
They are, Judge. Can you hear me?
Yes.
This is Amy. Yeah, they are.
Okay, so if the Chief Justice or the clerks have any insight or want to jump in at any point, feel free.
Can I expand it up here?
Okay, so let's begin. This is a tough case. It split the appellate court, and there's a vigorous dissent in the Supreme Court decision. Decided recently. Attorney for the appellant was Josh Castleman. There's Josh from Rubin and Levine, and Randall Schaus for the appellee. It's Mr. Schaus. This case has received quite a bit of attention. If you just Google it, a bunch of stuff comes up. Here's the write-up in res gestae. Across Indiana, judges, clerks, court reporters, bailiffs, and others are working to resolve over 1.5 million pending cases. In 2023, our trial courts dispose of over 1 million cases. Respect for the finality of judgments is thus crucial to the efficient functioning of our legal system. Finality conserves limited resources, provides certainty and stability, and protects the interest of parties by enabling closure and reducing prolonged litigation. While our trial rules recognize the importance of finality, they also provide litigants with the tools to set aside a final judgment in limited circumstances. But courts must enforce the procedural and substantive requirements that cabin those tools.
White upstairs and see if there's any white up there that needs to be done?
Yes, the case.
All right, please mute your phone if you could, your Zoom if you could. Ian, any
Understand that it's not on good, okay?
any comments on these initial sentences?
I guess my thought is, you know, the 1.5 million is just kind of a mind-boggling number.
Right.
Outside of that, I think, you know, a significant portion, at least in the collections area, are resolved by default judgment and don't end up in litigation. If not that, a lot of them end up in summary judgment, which, like the case we have today, is one route that it adds, and I think it sets us up good for the rest of the case.
Ian Septoski?
No, I would agree.
Long ago, I was an English prof, as I mentioned, and when I had students write their essays, they had to have a hook to begin their essay, and one solid hook that we used was statistics. And I think that's what the author has done here. Here, the trial court entered summary judgment against the defendant for an unpaid business debt. Within 30 days of that decision, someone else admitted in an unsworn letter to fraudulently signing the loan in the defendant's name. But the defendant did not file a motion to correct error or perfect an appeal. Nevertheless, on the defendant's motion, several months later, the court set aside its judgment based on fraud under Trial Rule 60B3. Any comments, Ian?
Well, I think that procedurally, what the court did in this case was, just to kind of maybe give away my opinion, I think what the court did was correct procedurally. I think the interesting and perhaps the most controversial thing about this case was more having to do with the fact that it was a pro se party who was so moving in this case.
So Ian Septoski, you deal with a lot of pro se individuals. Do you treat them differently than in situations involving a lawyer?
Well, I would say you have to in certain respects. You always have to, I think, protect your client's interests, but also juggle a defendant's interest in maybe understanding what's happening in the case. And I try to do as best I can, and by making the letters and pleadings that I file, hopefully as simple and straightforward as possible.
Ian Flora?
Well, I agree with everything other Ian said. I guess the most interesting point I have on this is, I started doing bankruptcies for about 5 years and have been doing creditors' rights since about 2010. And motions to set aside judgments were something that, from 2010 to 2016, I was getting like one a month, maybe less than that. And, now I probably see 4 or 5 a week. I mean,
Wow.
So the number of these has just absolutely exploded. And, not many of them have the issues here of the 60B3 with the fraud. Most of them are start with a lack of service and then trying to put together a meritorious defense. But they have just exploded. And I'm not sure exactly why that is, but a portion is, I mean, there is a lot of easy Google information on the internet, also through Reddit. And then we do have a number of courts in the state that have opened up the self-help centers and have manned self-help centers and things like that, that I think have led to a real significant increase in the amount of these that we see.
Thank you. So here's 60B3, dealing with fraud, misrepresentation, or other misconduct of the adverse party. Applying our trial rules and well-settled case law, we hold that the trial court abused its discretion in granting this relief. Trial court could not use Trial Rule 60B3 to grant relief on the grounds that the defendant could have raised in a motion to correct error. And there is no evidence that the alleged fraud prejudiced the defendant's presentation of her case. We therefore reverse. So just big picture, Ian Septoski, did you agree with this decision to reverse, or would you have come out differently?
Yes, no, I definitely agree with it. And as I stated, I think procedurally the facts were pretty clear. The party, Ms. Liu, she did file an appeal, but it was dismissed because she didn't file a brief. And then it was during the proceeding supplemental phase of the case when she brought in a letter purporting to be an admission of fraud. And that's when the trial court considered that and set aside the judgment, but it did so wrongly applying the summary judgment standard rather than any sort of fraud consideration.
Ian Flora, did you agree with this decision?
I do agree with this decision. When I had just made the point about how many of these motions to set aside judgment I see, 99.9% of them are out of default judgments and have to do with an issue of non-service or not having an opportunity to defend themselves. When you have a summary judgment that is, a type of judgment on the merits, the motion to set aside is not meant to be a stand-in, or in this case, kind of a last-ditch effort for a failed appeal, or even if there was grievous error, to file the motion to correct errors within the 30 days. In this case, you had people that were participating and filed a response to the complaint, were well aware of the case, had opportunities to do their research, hire legal counsel, bring up these issues at the summary judgment, and did not.
Facts and procedural history. This case presents an unfortunate cautionary tale for individuals who represent themselves in civil litigation. In 2018, Automotive Finance Corporation, AFC, extended a loan a little over $100,000 to Monmars Automotive Group, LLC, for use in its automobile sales business. As part of this financing, Monmars and Golden Dart Holdings, LLC, entered into a demand, promissory note, and security agreement, the contract, signed by their managers, members, Ming Liu, her then husband, Ning Ao, and Liu's friend, Xiao Jiao Yang. The contract promised that Golden Dart and the three individuals would make full and prompt payment to AFC if Monmars failed to pay. And a notary affirmed that Liu, Ao, and Yang had each personally appeared and signed the contract. In 2020, after Monmars defaulted on its payments, and AFC filed a complaint against Monmars and its co-guarantors, Golden Dart, Liu, Ao, and Yang. About 3 weeks later, Liu, who represented herself at the time despite speaking limited English, filed an unsworn letter with the trial court. The letter explained that she and Ao were now divorced. Monmars was Ao's company, and she and Yang either did not sign the agreement with AFC or did so without their knowledge. The same day, Ao also filed an unsworn letter that stated Liu and Lang were not involved in the Monmars and hadn't signed the documents. In March 2022, AFC moved for partial summary judgment and designated an affidavit authenticating the execution and notarization of the contract. 2 weeks after that, Liu responded to the motion by filing another unsworn letter with the court in which she claimed that she and Yang were not aware of AO's loan from Ms. AFC and asked the court to dismiss the claims against them. Liu also attached a confession letter from AO in their December 2020 divorce agreement, which assigned the AFC loan to him. In the attached confession letter, which was also unsworn, AO said that he had helped Liu and Lang to sign the contract, but hadn't explained what it was. About 5 months later, the trial court held a hearing on AFC's motion for partial summary judgment at which Liu and Yang appeared pro se and had the assistance of an interpreter. After the hearing, the court granted AFC's motion and entered final judgment against Momars, AO, Liu, and Yang, awarding AFC over $160,000. Within 30 days of that judgment, AO filed an unsigned letter saying he wished to appear in court and prove that he forged the signatures. Meanwhile, Liu filed a timely notice of appeal. In that notice, Liu stated that AO had arranged for an imposter to sign in place of herself and Yang, and that AO could testify in court. But after Liu failed to timely file an appellate brief, the Court of Appeals dismissed her appeal. Ian's, any thoughts on the facts so far?
I mean, it's an unfortunate set of facts. You have a pro se party coupled with English being her second language. I'm not really sure if she even spoke English. So obviously you've got the double consideration there, which happens all the time in trial courts, by the way.
I guess my take on it would be to just piggyback on what Ian said, that, yeah, I mean, a very unfortunate, not entirely unique, but a rare circumstance. But I think the issue becomes, like we go back to law school civil procedure, when we're in litigation, there's burden shifting. And the issue here is if it's not their burden to find a way to protect themselves, whose is it? Is it the trial courts to find some way to not trust their interpreter or their pleadings or interject themselves? That's an impossibility. And plaintiff's counsel is not in a position to, do something different, withdraw their summary judgment, withdraw their judgment, or do something that's going to penalize their client. So unfortunately, one of the biggest issues in this case is it plays out real bad, but the burden the whole time was with those folks to get proper representation and file proper pleadings.
How often do you see unsworn letters?
I don't recall ever seeing a sworn letter from the pro se party, Your Honor.
So they just write out their point of view and hope it helps.
Well, it almost always gets some kind of hearing.
That's true. That is our standard procedure. Correspondence come in, we set it for hearing. In the months following the trial court's entry of summary judgment, AFC filed motions for supplemental proceedings to collect its judgment. During that time, about 6 months after the judgment, Liu, now represented by counsel, requested an evidentiary hearing. At that hearing, AO testified to using Liu and Liang's information to apply for the loan and arranging for 2 foreign students from China to sign their names. Holy smokes. And Liu testified that AO had revealed his fraud to her during their separation, a separation which had ended with their divorce 1 year before AFC moved for summary judgment. What do you think about that, Ian?
Well, the implication there is, and as the court went on to point out, that the implication was that Liu knew several years before bringing it up at the proceedings supplemental stage that this fraud had occurred.
So one huge takeaway is if you think there's fraud or know about fraud, bring it up early, not after the deadlines. Liu then moved for relief under Trial Rule 60b-3, arguing AO's testimony amounted to newly discovered evidence of fraud. AFC opposed relief, arguing the evidence wasn't newly discovered and Liu had failed to pursue the matter on appeal. The trial court granted Liu's motion, finding that Ao's testimony created genuine issues of material fact and showed Liu had a meritorious defense. The court later granted Yang relief on the same grounds. AFC appealed both decisions, and the Court of Appeals issued conflicting published opinions. In Yang's case, the majority of the panel reversed, concluding she hadn't shown that fraud prejudiced her ability to present her case. But here, a majority of the panel affirmed, finding sufficient evidence that fraud prevented Liu from presenting her case. Judge Brown dissented, noting Liu failed to timely designate evidence in opposition to AFC's summary judgment motion or to argue that fraud prevented her from doing so. With a split in precedent on an important issue implicating our trial rules, we granted AFC's petition for transfer. Ian?
Well, one thing that stood out to me about this passage was that the split in the opinions in the appellate court almost I would have expected to be the reverse. In the Yang case, the court reversed, finding that the party was prejudiced by the alleged fraud, and the party in that case, Yang, was one person. I'm sorry, the opposite. The Yang case, the Court of Appeals did not find the court find that the fraud precluded her from presenting the case, and I sort of am surprised by that because Yang was one party removed from the knowledge of the fraud. So I would have thought that if anything, Yang would have had the better case there to say that I was prejudiced by this alleged fraud because I had absolutely no idea that it had occurred. I wasn't the one married to the person. I didn't learn about it during their separation or prior to their divorce, and so I am more prejudiced in this circumstance.
Yeah, good point. Ian Flora?
Yeah, I don't have anything better to add than what Ian Septoski just said.
All right. And by granting transfer, we vacate the Court of Appeals decision in Liu's case. Standard of review. Review a trial court's decision under the trial rule 60B3 for an abuse of discretion. An abuse of discretion occurs if the trial court's decision is clearly against the logic and effect of the facts and circumstances, or if the court has misinterpreted the law. Anything on standard of review, Ian?
No, I mean, that's just the standard of review that's applied to these opinions when they go up on appeal. So.
Just routine. Discussion and decision. In rendering final judgment, our trial courts put an end to the controversy before them. So hearkening back to the finality theme. Accordingly, entering final judgment deprives a court of its inherent power to reconsider, vacate, or modify any previous order. Indeed, a final judgment can be modified only so far as the judgment itself, the statute, or court rules permit. This presumption of finality provides certainty and stability, allowing parties to rely on decisions as conclusive. That said, our trial rules provide litigants with tools to set aside final judgments in limited circumstances. For example, a party can file a motion to correct error within 30 days of the court entering final judgment. That's Trial Rule 59C. And Trial Rule 60B enumerates grounds for parties to obtain relief based on circumstances that couldn't be discovered in time for a motion to correct error. This rule also acknowledges the power of a court to entertain an independent action to relieve a party from a judgment, order, or proceeding, or for fraud upon the court. But this remedy is extremely limited. Each of these tools has procedural and substantive requirements that apply uniformly to all litigants. This includes pro se litigants who will be held to the same standards as a trained attorney and afforded no inherent leniency simply by virtue of being self-represented. Ian, what percentage of people you deal with are self-represented?
I think it depends on what you mean by self-represented these days. I would say 95% perhaps the people I deal with are acting on their own behalf, self-represented litigants. What I see very often in the collection world these days is the explosion of so-called debt relief agencies or debt management companies. Some of those agencies purport to represent the debtor or negotiate debts on their behalf in what I do. Occasionally, those companies are affiliated with attorneys. That's where I mostly see attorney involvement in cases these days, where they're hired through these third-party debt consolidators.
Yeah,
Mr.
that's absolutely correct. And I like the word explosion because, again, that's one of those, basically since COVID, we'd see a little bit before then, but since COVID, just a ton of them. And I mean, they kind of muck things up a little bit because they're generally not people that you can get on the phone. If you do, they're not familiar with the individual case you're talking about. The pleadings they file in cases, the response to a complaint, a response to summary judgment, or essentially loading up a pilgrim's blunderbuss with nails and rocks and shooting it at it. Shooting it at the turkey for Thanksgiving. I mean, you get latches and collateral estoppel, and then those folks show up in Judge Telloyan's court, and their attorney on paper is something, something, something out of Fort Lauderdale, Florida. That's never
Right.
met them, never talked to him. They have no idea who he is. And then when you ask them how latches applies, they don't know what latches means. So we see a lot more of that than we used to. And I mean, the super complex issue out of that is, I have a case with one of those the other day over in Porter County where the woman pro se filed her own motion to dismiss that was granted, that violated her contract with her debt settlement company, who is still reaching out to us trying to settle the case and didn't want it dismissed. And then ultimately did have to talk to their client where she filed the motion to reinstate. So yes, a lot higher percentages of people, when you look on Odyssey, have an attorney listed as representing them, but that unfortunately doesn't mean that they're aware of it or know what that person's doing, or that person is doing anything that is helpful in litigation other than hopefully trying to set up a payment arrangement or a settlement, which ultimately is what we all want.
I said in Superior Court 7 here in South Bend, I'd say civil division, and I'd say at least half, for sure a third of the parties are pro se, which creates its own challenges and difficulties. Accordingly, a party proceeding pro se must be prepared to accept the consequences of his or her action. While trial courts may facilitate a fair hearing for pro se litigants by explaining legal concepts in everyday language and informing litigants what is expected of them, they must enforce the law. Here, AFC asserts that the trial court abused its discretion in granting Liu relief under Trial Rule 60b-3, arguing that Liu could have raised AO's alleged fraud by designating evidence in response to AFC's motion for summary judgment, or by moving to correct error after judgment was entered. Liu concedes that the evidence she presented in her Rule 60b-3 motion had already been presented to the trial court through the unsworn letters before EFC obtained summary judgment, but she contends the court did not abuse its discretion in granting her relief. We agree with AFC. In reaching that decision, we first outline how a litigant such as Liu can oppose summary judgment and seek relief in the trial court from a final summary judgment decision. Then we explain why the court here misinterpreted the law in granting Liu relief under Trial Rule 60B.
Where'd you get ours from?
Yeah,
Hey,
saw Lane.
All right, please mute your Zoom. Okay, Ian Flora or Septoski, any comments before we jump into the substantive part here?
Yeah,
No, I
I
think
am.
we've
Bet
already
you guys
addressed
want
that.
some hamburger and noodles?
Please mute your Zoom.
I do not, Judge.
All right. Ian Septoski.
No, Your Honor.
Okay. The trial court could not grant Liu relief from final judgment on the basis of fraud. To explain why the trial court misinterpreted the law in granting relief to Liu based on fraud, we first set out how a party may oppose summary judgment and how they can challenge a judgment in the trial court once it becomes final. What follows is a primer on opposing summary judgment. After clarifying the relevant trial rules and case law, we then applied them to this case. We ultimately conclude that the trial court improperly granted relief under Trial Rule 60b-3 as a substitute for a timely motion to correct error and a subsequent appeal. And we find that Liu failed to show that Ao's alleged fraud prejudiced her ability to present her case. A, parties challenging final judgments based on fraud must comply with the procedural and substantive requirements. Our trial rules require that parties receive a fair hearing for judgment, including summary judgment. The rules also lay out procedures for challenging final judgment, but these same rules cabin opportunities for relitigation in the interest of finality. Ian's, any comment here?
No, I think this is procedural issues related to summary judgment and et cetera.
Okay, so pretty basic.
Yes,
Isn't often that you see cabin as a verb. My old
like it.
English teacher coming out, I asked GPT if you could use cabin as a verb, and it said yes, and gave a quote from Shakespeare's Macbeth. As we explained below, a party can designate evidence at the summary judgment stage until the deadline expires. Once a judgment becomes final, they can timely show that an adverse party's fraud prejudiced the presentation of their case. But a trial court cannot grant relief without enforcing these requirements. Making exceptions would lead to disparate treatment of litigants, and by improperly permitting relitigation of issues already determined, undermining finality. The lodestar here. We begin by explaining how a party can oppose a motion for summary judgment. Summary judgment decides a case or issues in a case without a trial. This is inappropriate when, after drawing all reasonable inferences in favor of the non-moving party, the designated evidence shows no genuine issue of material fact, and the movement is entitled to judgment as a matter of law. If the movement makes this showing, the non-movement has 30 days to serve a response in any opposing affidavit and designate evidence showing an issue for the trier of fact. Ends on summary judgment. How common is this procedure? And when you see summary judgment, how often does the defendant submit these pieces of evidence?
Summary judgment's extremely prevalent in the collection type cases that I primarily work on. I would say maybe a third of the time I see answers filed by defendant. However, the responses that are usually filed by defendants don't necessarily comply with the trial rules having to do with admissible evidence in the form of affidavits. Nonetheless, I think courts often show a substantial amount of deference to a pro se defendant, even if they file something that doesn't necessarily comply with the trial rules.
So you said a third of your cases, there's some type of summary judgment motion?
I would say, I wouldn't say a third of the cases are the summary judgment. I would say in the cases that I file a motion for summary judgment, I would say in a third of those cases, the defendant files some sort of response.
All right. I have a question for you on response and non-response and summary judgment. Let's say the collector plaintiff files a motion for summary judgment. Defendant doesn't file anything, doesn't designate any evidence, but then shows up for the summary judgment hearing. Can they testify, and can the court take their testimony into account?
Not according to the trial rule 56 standards, and also I think that's mentioned in this opinion, that the court cannot consider filings of that party after that deadline.
So I'm not saying filings, I'm saying just their testimony. Can they say it wasn't me or there was fraud or?
I would say no. I would say that that testimony would have to be presented in the form of an affidavit prior to the summary judgment hearing. I've made that argument before in cases in which a party appeared for a summary judgment hearing. Nonetheless, I understand that the courts do show a lot of deference to a pro se party when they show up for those hearings. I can understand that.
Ian Flora, what's your take on that issue? If the debtor defendant does not designate any evidence, can they still show up the summary judgment and speak and say it's not them or there was fraud or give their point of view?
Okay, so I mean, I've kind of got 3 points on this. My first one is, as plaintiff's counsel, I don't really mind court setting these hearings, even if there's not a response, because a lot of times the defendants do show up and it's kind of free prose up, you know, it's a opportunity to talk about the case, set up payment arrangements, that kind of thing.
It's a good way to look at it.
As far as they haven't filed a response, do they get to talk to Judge Telloyan? I would say yes, but it's limited. Limited to a couple of things. Yes, number one, if they're coming in and essentially starting with a judge, I object to the motion and I need more time to respond because I wasn't served the motion. I was served an incomplete motion. Something as to essentially finding fraud, mistake, excusable neglect in their timing of responding to the summary judgment. I think that's something they can address the court about, because, you know, if you don't have that hearing or you don't get to talk, well, then immediately we're into the motion to correct error within 30 days or a motion to set aside a judgment, when it could have been resolved there, where the court could have been apprised of the whole facts and made a decision at a rescheduled summary judgment. The other issue is, I've read cases and I've heard trial court judges make this argument, and I don't know if I'm completely persuaded, but if the defendant's testimony is kind of limited to or goes directly to the sufficiency of plaintiff's complaint and documents put forward in their summary judgment, almost arguing that, look, plaintiff hasn't put forward enough that they would even get a default judgment, something like that. I think then, yes, I think in a limited circumstance, because that's not relying on a response to the summary judgment or their personal affidavits when it's pointing out plaintiff's motion and what's already in the record, I think they can make an argument that it's not sufficient on its face to allow for a summary judgment.
And I would agree with that procedure. I would say that if the court is considering the defendant's argument at the summary judgment hearing, that's appropriate if the argument's on legal grounds and the sufficiency of the plaintiff's pleading, because the trial Rule 56C requirement is, in a nutshell, that the plaintiff comes forth with an affidavit that makes a prima facie showing in support of their case, and then the burden switches to the defendant to set forth affidavits controverting that. I think Ian's absolutely correct that if the defendant wants to make an argument that the plaintiff's affidavits didn't meet that requirement, they can certainly do that, because that's not evidentiary testimony that would, put forth their actual case, I think.
If that evidence includes witness testimony, it must be presented under oath, such as by a sworn affidavit. Though trial rules 56F and I permit trial court to extend the 30-day limit, the court cannot consider summary judgment filings made after the deadline expires. Important. And summary judgment cannot be reversed on the grounds that there is a genuine issue of material fact, unless the material fact and the evidence relevant thereto shall have been specifically designated to the trial court. Once a trial court enters final summary judgment, trial rules 59 and 60B come into play. Trial rule 59 gives a party 30 days from when the court notes judgment in the chronological case summary to file a motion to correct error. That motion can raise a broad range of challenges, including newly discovered evidence. Trial Rule 60B also enables a party to seek relief from summary judgment. But this rule is meant to afford relief from circumstances which could not have been discovered during the period a motion to correct error could have been filed. And thus, Rule 60B cannot be used as a substitute for a timely motion to correct error and a subsequent appeal. Relief under Trial Rule 60B is limited to enumerated grounds and applicable time limits. One such ground, which is relevant here, is for fraud of an adverse party. Under this limited exception to the general rule of finality of judgments, a party must show that fraud prevented them from fully and fairly presenting their case. They must also demonstrate a meritorious claim or defense to ensure that granting relief would not be an empty exercise. What about that little subpoint of bringing forth a defense? Any comments on that?
That was the basis or the subject of a prior deep reading we did, I think last year, about what the standard is for a meritorious defense. And it's changed over the years. But my understanding of the law now is that the moving party must be able to present some credible evidence to suggest that they have a defense to the claim, not the old standard that the judgment would change and an injustice would be foisted upon them if the judgment was not reversed.
And they must make these showings not more than 1 year after the judgment was entered. When a party seeking relief cannot meet Trial Rule 60B3's requirements, such as when the fraud is not chargeable to an adverse party, they have two other ways to attack the judgment based on fraud. The first, recognized under Trial Rule 60B's savings clause, is through an independent action requesting a trial court to relieve a party from a judgment, order, or proceeding. But this remedy is extremely limited and not an opportunity to relitigate an issue that was or could have been litigated in the original proceeding. Ian, have you ever seen a savings clause action?
Yes.
And how did that go?
Well, so I think a lot of the case law that I'm familiar with was under that savings clause, which I think is 60B8. And the standard for that, it's actually a pretty interesting standard, I think, because the case law indicates that you can't simply allege something under 60B8 that you were that falls under one of the other subprovisions of 60B. In other words, you can't get over the 1 year deadline for a 60B1 motion by filing a 60B8 motion alleging there was a mistake or excusable neglect, for example.
Ian Flora?
I've seen similar things in older small claims cases where they've got a time barred issue because they may have appeared at a 10-year-old small claims judgment, appeared at a proceeding supplemental 5 years in, that kind of blew their timelines for the normal 60Bs and end up filing the independent action. Kind of based on came in for the pro sup, does a questionnaire with an attorney, doesn't really understand what's going on, maybe wasn't garnishable at the time, left with a dismissed pro sup, didn't understand they still had a judgment 10 years later. They're back and about to have their wages garnished and it's too late for the 60B. So they're filing, an independent action at small claims court on it. I see those, but not very often, maybe 2 or 3 total.
Okay.
That is interesting. I when it says an independent action, I've never really been 100% clear on what that requires. And a lot of the courts that I've practiced in front of maybe also don't understand what an independent action is. So I would actually be interested in knowing Your Honor's perspective on that and what an independent action means. Does it mean that the person has to file a complaint under a new cause number? That's what
I took
before.
it to mean, but I have never seen one of those, although I've only been on the bench 3 years. And the party must still show how fraud undermined the presentation of their defense. Secondly, the savings clause also recognizes a trial court's inherent power to set aside its judgment if procured by fraud on the court. But this must involve an unconscionable plan or scheme to improperly influence the court's decision. All in all, our trial rules afford parties ample opportunities to oppose summary judgment and challenge a final judgment based on fraud. So I think the author makes a good point here that we love finality, but there are plenty of ways to oppose a final judgment. But in the interest of finality, these opportunities include procedural and substantive requirements, and trial courts cannot excuse any party, including a pro se litigant, from compliance with these constraints. Having laid out the applicable framework, we now turn back to this case to determine whether the trial court improperly granted Liu relief. Liu's request for relief based on fraud was both untimely and unsupported by any evidence that fraud impacted her defense. AFC argues that the trial court, by granting Liu relief under Trial Rule 60b-3, abused its discretion in three ways. One, by considering grounds that could have been raised by a timely motion to correct errors and a timely direct appeal. Two, by applying Trial Rule 56 summary judgment standard instead of Trial Rule 60b-3 standard. And three, by granting relief without showing that fraud prevented her from designating evidence in opposition to summary judgment. So the first basis for reversal is sufficient to resolve this appeal. We agree with AFC on all 3 points. The trial court misinterpreted the law by using relief under Trial Rule 60b-3 as a substitute for timely motion to correct errors and appeal. Within 30 days of the court noting final summary judgment for AFC, AO informed the court that he wished to admit to forging Liu's signature on the contract. Liu then filed a notice of appeal saying AO could testify about his imposter scheme. Thus, assuming Liu had newly discovered evidence of AO's alleged fraud, she could have raised it in a timely motion to correct error under Trial Rule 59 and subsequently appealed a denial of that motion. But as a motion under Trial Rule 60b cannot be used as a substitute for either of those steps, it was improper for the trial court to grant Liu relief under Rule 60b-3. The court also misinterpreted the law in 2 other ways. It granted Liu relief upon a finding that AO's testimony demonstrated genuine issues of material fact. But by that time, the 30-day period for considering new evidence on summary judgment had long since expired. Additionally, the testimony AO and Liu gave did not satisfy the Trial Rule 60b-3 fraud standard. Liu's own testimony indicated AO had disclosed fraud to her during their separation, and their divorce settlement executed in December 2020 assigned the AFC loan to AO alone. As such, Liu was in a position to designate evidence of fraud at the summary judgment stage in 2022. Thus, we reach the same conclusion here as former Chief Justice Shepard did in his opinion for the majority in Yang's case. The evidence of AO's alleged fraud in executing the contract related to the merits of AO's claim. It didn't show how that fraud prejudiced Liu's ability to present her case. So, drops the trump card, Chief Justice Randall Shepard. I don't know if we'll have time to get to the dissent, but the dissent also cites former Chief Justice Shepard. While it is regrettable that Liu failed to timely file sworn affidavits or properly designate evidence to show that she did not knowingly sign the contract, AO's alleged fraud didn't keep her from doing so. Liu's evidence of fraud did not therefore warrant relief under Trial Rule 60b-3, nor for the same reason could such evidence support relief through an independent action. In sum, the trial court misinterpreted the law in granting Liu relief under Trial Rule 60b-3 and thus abused its discretion. We sympathize with Liu and over her now ex-husband's apparently fraudulent execution of the contract and her subsequent liability for the debt. We also sympathize with Liu's difficulties understanding English and appreciate she was not represented by counsel until later in the proceedings. But our sympathies aside, Liu did not follow the legal avenues available either to oppose AFC's motion for some judgment or to raise AO's alleged fraud in a motion to correct error. To conclude otherwise and make an exception for Liu on this record would amount to disparate treatment in this case and lead to relitigation of previously determined issues in future cases. Such a result would significantly undermine the finality of judgments. So once again, tying into the big picture of finality. Conclusion, for the reasons explained above, we reverse the trial court's decision to grant Liu's relief from judgment under Trial Rule 60b-3 and remand for the court to reinstate summary judgment for AFC. Chief Justice Rush. Massa, Slaughter, Moulter concur. All right, it's 12:52. I was wondering if the Chief Justice or her clerks had anything they wanted to say about the majority opinion. All right, hearing nothing, we'll move on to the dissent. Justice Goff, I respectfully dissent. The court's decision today leaves Ming Liu, a non-native speaker who was unrepresented for most of the proceedings, liable for $163,000 despite being a victim of fraud. Doesn't seem very fair, does it? AFC obtained a summary judgment against Liu based on a forged loan agreement that she never signed. No one questions that she's a victim of fraud, so the trial court granted Liu relief from the judgment under 60B, and the Court of Appeals affirmed. Because the trial court and Court of Appeals have corrected this fraud, I would not use this court's discretionary review under Appellate Rule 57H to reverse a just outcome. A party can file a motion under Trial Rule 60B not more than 1 year after a judgment to seek relief when the judgment was obtained through fraud, misrepresentation, or other misconduct, and when a party alleges meritorious defense. Outback Steakhouse, this court held that Indiana courts applying the fraud provision of subsection 60B3 have required a movement to show that fraud prevented the movement from fully and fairly presenting the movement's case. In my court, the trial court did not abuse its discretion in granting Liu from relief under this rule. Liu's then husband, Ning Ao, obtained a loan from AFC by forging Liu's signature on the loan document. Ao had a student from China use Liu's identification card to impersonate her in front of a notary. When AFC first filed its complaint, Liu sent a letter to the trial court saying Xiao Jiao Yang and I did not sign the agreement with the AFC and did so without our knowledge. In Ao's confession letter that was submitted during the summary judgment proceedings, Ao said that he helped Yang and Liu sign the loan. And in another letter submitted during the summary judgment proceedings, Liu said she was not aware of Ao's loan from AFC. He simply explained his company needed a signature from an American citizen. These letters during summary judgment stage suggest that Liu did not sign the documents or might have signed them without fully understanding them. The first time Liu specifically alleged forgery was in the notice of appeal after summary judgment was entered. In the notice, she said Ao had an imposter take her place and sign and get notarized. In the evidentiary hearing for supplemental proceedings, Liu testified that during the separation, Ao told her the truth, used her and Xiao Jiao's Yang's name to apply for a loan. The court reads this to mean that Liu was aware of the forgery before the summary judgment was entered. But the trial court could have reasonably concluded from Liu's testimony that even though she knew Ao used her name, she was not aware of the forgery, specifically at the time, and might have thought she signed the documents without understanding them. This is sufficient to affirm the trial court's conclusion that fraud occurred, and the fraud prevented Liu from presenting her defense during the summary judgment stage. Liu didn't have the opportunity to litigate fraud in her original proceeding, and Ao's fraud undermined her defense. As for Liu's appeal, it was ultimately dismissed on procedural grounds. Liu appealed the initial judgment but did not file an appellant's brief, so her appeal was dismissed with prejudice. An issue which was raised by or could have been raised by a timely motion to correct error and a timely direct appeal may not be the subject of a motion for relief from judgment under Trial Rule 60. But ultimately, the merits of Liu's fraud claim have never been adjudicated. The trial court and the Court of Appeals recognized this and therefore granted her equitable relief from AFC's judgment. Given the trial court's inherent power to modify an inequitable judgment, we would hold that the trial court did not abuse its discretion. To protect our law-giving function, this court has authority to select what it will consider from the trial courts or the intermediate court. Changing the Constitution by Chief Justice Shepard as the state court's last resort, we should reserve our discretionary review for the most significant issues. Here, the court, in a well-reasoned opinion, emphasizes the issues of finality as crucial to the efficient functioning of our legal system. But in doing so, the court uses our limited resources to reverse a trial court that was trying to correct an obvious wrong outcome. Finality doesn't always take priority over fairness. When invoking them, we defeat justice. They acquire the position of being the ends instead of the means. We should tread carefully, given the trial court's necessary discretion to address fraud and preserve confidence in the judiciary, rather than focusing on a less critical issue. Leo should never have been liable for this debt in the first place because she never signed the loan docs. Once again, non-native speaker, unrepresented. The trial courts and Court of Appeals used their authority to correct this outcome. And instead of letting this just result stand, we have used our limited discretion to reverse. Because I would let the Court of Appeals decision stand, I respectfully dissent. All right, it's 12:58. Got 2 minutes left. Ian's, any thoughts on the dissent?
My thought on the dissent is that it's a very subjective standard. The justice was saying that in this case, because of all this injustice that happened to this party, I would have relieved that party of the procedural requirements of the NI trial rules. I think that's a dangerous idea. I think the trial rules are there to protect all parties and to ensure a level playing field among participants in the legal system. And if the court were to, in every case, let a party off of some of the rules requirements because of sympathies or, as I said, a subjective standard, I think that would be a dangerous outcome, Your Honor.
Mr. Flora, the final word goes to you.
What he said, it's, these equitable principles applied to contract cases are a slippery slope. I started with saying that, I see somewhere between 4 to 10 60B2 motions a week. And I will tell you, all of them require a meritorious defense. Less than half of them have it in their pleadings or argue it at the hearing, and less than half of the judges care. The only issue they turned to was the old standard, which was whether or not they were served and whether or not that means the court had jurisdiction over the defendant. That is an issue where the standard is at least more likely than not and requires some amount of evidence. And more than half of these hearings I'm doing, the only evidence is that person saying something. And I'll tell you, those are getting set aside all the time on a hearts and equity. And at the end of the day, the trial rules need to mean something. Even in the case that's here with Ming Lu, look, she can bring her own action against her ex-husband. She could have the divorce decree rendered to a judgment. And in fact, some of what he did could, fall under criminal codes, and she could talk to a local prosecutor about that and maybe get a restitution order. She's not without remedies. And if ultimately that makes her insolvent, I don't think the Supreme Court should have set aside a judgment that was properly in place. I mean, if she needs to be insolvent and liquidated in a bankruptcy, there's a remedy for that too. We don't have debtors' prisons. I'm sympathetic to the dissent. He's arguing with his heart, but unfortunately the heart makes bad law. And thanks, everybody.
The heart makes bad law. We'll go ahead and end with that statement. It's 101. Make sure that Amy McGuire has your information for CLE credit. Amy?
Judge, just quickly, I think Justice Rush was trying to unmute. I'm not sure if that happened. And I also just wanted to comment quickly that there was a comment in the chat. I don't know if you saw that.
No, I did not.
I think it was Stephen Drendel, but there was the comment, compliance with TR 56 is tough for many attorneys, impossible for pro se parties, a reason small debts, not like in this case, should be required to go to small claims court.
Okay, thank you. Chief Justice Rush, any comments?
I think we have a muting situation.
Okay.
I'm not positive if that's what it is. But.
Okay. Well, Chief Justice Rush, if you're interested or if you're listening, thank you for joining us. And the CLE is adjourned.
Thank you.
Thank you. Thank you, everybody. Don't forget the code word was finance.